I want to welcome everyone to the real estate section of the Beverly Hills Bar February presentation by Lawrence Jacobson, which will be the top 2020 cases affecting real estate. Before we begin, I wanted to mention that the list of cases that Larry will talk about can be found in a link that's in the chat of the Zoom. So you might take a look there for the list of cases that Larry will talk about. This is not a PowerPoint presentation. Secondly, I would like to invite anybody who's interested to contact me. I am the chair of the real estate section along with Elizabeth Dryden. We're co-chairs, and we welcome anybody who might want to participate as part of our executive committee in helping to plan programs and other events for the real estate section throughout the year. We have a Zoom meeting usually once a month, not quite once a month, and in addition to the programs that we're putting on. In terms of questions, I will try to monitor those questions in the chat. You can use Q&A if you want, but I'll probably be looking mainly at the chat and assist Larry with any questions that people may be asking in the course of his presentation. It's a great pleasure for me to introduce Larry Jacobson. Larry is a past president of the Beverly Hills Bar Association. He's a double graduate of UCLA, both undergrad and law, where he was a senior editor of the UCLA Law Review and also graduated as a member of Order of the Coif. In his over 47 years of practice, Larry has extensive experience in real estate and business matters, including business entity formation and restructuring, purchase and sale of businesses, succession planning, purchase, sale, management, and refinance of commercial and residential real estate, and tax-free exchanges. Larry has testified numerous times as an expert witness in cases involving interpretation of real estate documents, real estate and mortgage brokers' standard of care, and legal malpractice involving real estate, corporate finance, mergers and acquisitions, legal ethics, and fee disputes. Larry has also written and lectured extensively on business, real estate, and ethics-related matters. He's taught for the USC Broker Development Program and Graduate Realtors Institute of the California Association of Realtors, and he's also a regular lecturer really every year for CEB, and he's reprising that presentation for us today. Larry's the recipient of the CEB Bar's 2011 Spirit of CEB Award for his long work with them. He served as a judge pro tem in LA and Beverly Hills municipal court systems. He's been an adjunct professor in the area of real estate secured transactions and administrative law. He's a contributing author to the CEB 2-volume treatise, California Real Estate Brokers, Law and Litigation. And he formerly was vice president of legal affairs for the California Association of Realtors and has been legal counsel to a number of boards of realtors, including currently the Newport Beach Association of Realtors. So Larry, thank you very much for bringing your program to us again and for updating us on last year's cases. Thank you.
Thank you, Howard. I probably need to update my resume. Actually, I've been at it for, I think, 52 years. Okay. Anytime that I do this program or anytime I review anyone's top 10 list of cases, I always recall an incident that happened at the Harvard Law Review many years ago. when they were selecting cases they felt important enough to discuss as case notes. And someone suggested a case, and the Board of Editors decided they wouldn't publish it. They thought no one would be interested because it was just another PI case. It was, of course, Paul's graph. I don't think we have any Paul's graphs this year, but bear in mind there are lots of cases out there, and if I miss one that turns out to be really important in the future, my bad. Okay, first case we're going to talk about is an easement case. Gammerberg versus 3000 East 11th Street, LLC, 44 Calap 5th, 424, 2020. In 1950, there were two lots adjacent. And since it'd be hard to follow if I use the names, I'll try to simplify it. Call them Lot A and Lot B. Lot A is owned by one. Lot B is owned by two. One wants to improve the building on Lot A. So he goes to the Department of Building and Safety, and they say, when you expand the building, you don't have enough parking. You've got to arrange to get more parking. So one looks across the fence at Lot B and sees there's a large parking lot. So he goes to two, and he works out a letter agreement in which two agrees to allow lot one some additional parking. Giving him 8 parking spaces. Letter agreement was notarized and given to the Department of Building and Safety. He said this resolves the parking problem, and they issued the permit. Fast forward to a few years ago when this case is filed. One had sold Lot A to 3, and 2 had sold Lot B to 4. 3 wanted to do some construction work on the property. And he went to the Department of Building and Safety, and he saw on file the signed and notarized letter agreement giving him access to 8 parking spaces on parcel B. So he sends a letter to 4, sending him a copy of the agreement and asking him to specify where his 8 parking spaces were. 4 ignores him. Action for declaratory relief. The lower court held that the letter agreement would be binding on 4. The Court of Appeals reversed. The Court of Appeals held that with no constructive notice to 4, much less actual notice, that 4 was not bound by it, that it was really a personal agreement between 1 and 2, which did not run with the land. So, if nothing else, this case emphasizes the need to record a document affecting real property if you want to afford constructive notice, bearing in mind that not everything that's recorded gives constructive notice, but if it falls within a class, like, for example, an easement, then it would. Next case, in the area of finance, Miles versus Penny Mac Loan Servicing, 40 Calap 5th, 1072. It's 2019 appellate case. This case, the homeowner borrower defaulted in 2008. Nothing happened until a foreclosure was started in 2017. In the interim, the lender had assigned the mortgage to another party. And then they proceeded to foreclose. Miles filed an action for wrongful foreclosure, making several arguments. One is that because the foreclosure took place so long after the default, that the lender could no longer default. Also, in question of what was done wrong in regard to the assignment, he asserted that everyone knows there was a lot of monkey business in the mortgage markets in the past decade, and had no facts to otherwise support his case. So it was hardly surprising that he lost. The Court of Appeals held that to say that a delay in proceeding with the foreclosure invalidated the right of the lender to foreclose was, quote, illogical and incorrect. The plaintiff seeming to suggest that a borrower, by refusing to pay, can prevent a lender from assigning the debt, which is not the case. Probably one of the more creative complaints against the lender in regard to a foreclosure. Next case, Colley versus Eschaton, 51 Calap 5th, 943, 2020 case. This involves a homeowners association. Escalon was a developer, and they developed two adjoining tracts. One tract was single-family residences, and the other tract was rental units. There was a single homeowners association that governed both of the parcels. The homeowners association had 5 directors, 3 appointed by Escalon, because it still owned the units used as apartments, and 2 from the owners of the single-family residences. The tracts were relatively equal in size and shared the expenses 50-50. At some point in the future, the board of directors of the homeowners association voted to change the allocation, and the allocation was changed from 50-50 to 83.3 to be paid by the homeowners and 16.7 by the developer. The vote was 3-2. Not surprising, the 3 votes were the directors appointed by Escalon. The case then goes on to discuss the nature of fiduciary duty of a director of a homeowners association, which is they have a fiduciary duty, and that fiduciary duty is owned to the corporation and to the members of the corporation. That what they did was intrinsically unfair. There was no basis for it other than shifting the burden from the entity that was controlled by Escalon to the people who weren't part of Escalon. So it's a reminder when dealing with homeowners associations that the directors and officers have the same fiduciary duties as they would if it's a for-profit corporation. Next case, fraudulent conveyance case, Universal Home Improvements versus Robertson, 51 Cal App 5th, 116, 2020 case. In this case, the defendant was a partner in a family partnership. The defendant borrowed money from her sister. Thereafter, there was a lawsuit. She lost, and Universal Home got a substantial judgment. Before Universal Home could proceed on the judgment, the defendant transferred her interest in the family partnership to her sister in return for cancellation of the debt. Universal Home asserted this was a fraudulent conveyance. The court looked at the transaction and noted that the amount of debt forgiven by the sister was far in excess of the value of the partnership interest conveyed. Therefore, it would not be considered a fraudulent conveyance because it was a transfer for fair and adequate consideration. And the fact it was to the sister is not really relevant. This suggests something of a strategy if you're dealing with a failed corporation. We had a circumstance years ago where the corporation was underwater and the owners wanted to continue the business of it. And they formed another new corporation and entered into an agreement to buy the working assets of the underwater corporation in exchange for assuming debts of the underwater corporation. And the debts they assumed were all the debts of the creditors with whom they wanted to continue doing business. You know, if it was a one-shot deal and they didn't care whether the debtor was upset, whether the creditor was upset, they weren't paid, then that wasn't one of the debts assumed. And it survived attacks by the creditors because fair and adequate consideration was given. Constellation FLLC versus World Trading 23, 45 Calap 5th, 2020 case. This is a commercial leasing case. The lease provided that if the end of the term, the tenant did not vacate the property, the rent would go up to 150% of the original base rent. The tenant at the end of the lease did not move out. The landlord asserted the rental increase, and the tenant argued that it was an unlawful penalty and would be unenforceable as a penalty. The Court of Appeals disagreed, holding that in order for it to be an unenforceable penalty, there would have to be a showing by the tenant of a lack of bargaining power, a lack of alternatives. If he didn't like the 150, he could have rented a similar property from someone else. So there was nothing unconscionable about it. Next case is a rent control case. Owens versus City of Oakland Housing, Residential Rent and Relocation Board, 49 Calap 5th, 739, 2020 case. In this case, the owner of a single-family home who rented rooms out separately to a number of people transformed a single-unit dwelling into a multi-unit dwelling and was therefore not exempt from rent control. Most, if not all, rent control statutes have an exemption that rent control does not apply to single-family residences. As you may recall, in the debates over the attempt to rescind the State Rent Control Act, that was one of the concerns, was that local jurisdictions could now impose rent control on single-family residences where someone rents out a bedroom to a roommate. The fact that a property starts as a single-family residence, that's built as a single-family residence, but is converted to a property in which bedrooms are rented out to a multitude of people with a common use of the kitchen and the common area in the place, means it's not being used as a single-family residence. It's used as a multi-family residence, a boarding house. And as such, they're not entitled to the exemption. This case is interesting that last year, you may recall, there was another case which discussed the same issue and came to the same conclusion. And I'm presently involved as an expert witness in 2 cases involving this very issue. In one case, it's a real estate agent standard of care case where the real estate agent in the MLS represented the property was exempt from rent control. And the agent representing the buyer also said it was exempt from rent control because he called the rent control board and they said that single family residences are exempt. He never bothered to tell them that it wasn't being used as a single family residence. Plus the fact they were practicing law, which real estate agents shouldn't do. And the other case was a legal malpractice case where a property was sold and the seller represented that it complied with zoning laws and was exempt from rent control because it was a single family residence. And there were 2 issues. The issue was it in fact illegal? And second, whether the seller knew about it. And the lawyer handling the case neglected to prove either one. That's why he's being sued for malpractice. The attorney representing the plaintiff in the malpractice action took the deposition of the person most knowledgeable in Riverside, and he has deposition testimony in which the person most knowledgeable said, yes, it is illegal. You can't use it for that purpose. And he also produced, pursuant to the subpoena ducis tecum, an index of filings with building and safety, which showed that the seller was in fact aware. He had come in and talked about getting a conditional use permit. So the lawyer had missed both those, which explains why he lost the case. We are now entering a period of time where we will always have at least one case dealing with marijuana. That's where we are now. Mosley versus Pacific Specialty, Inc., 49 Calap 5th, 417, 2020 case. This case, landlord rents property to the tenant. Unbeknownst to the tenant, to the landlord, the tenant is using the property to grow marijuana. In order to facilitate the growing, he changes the electrical system. Because of the change in the electrical system, it shorts out and starts a fire, causing significant damage. The landlord files a claim with the insurance company, asserting that they have a liability to pay him under the policy. The insurance company pointed out a provision in the policy that prevents the property from being used for agricultural purposes. The court held that what the insurance company was overlooking was insurance code sections 2070 and 2071, which provide that an insured increases a hazard within its control only if the insured is aware of the hazard or reasonably could have discovered it through exercising ordinary care or diligence. Since the landlord had no knowledge at all about the marijuana growing, no knowledge at all about the change to the electrical system, and no knowledge that the change of the electrical system was done improperly, that he still was entitled to coverage under the insurance policy. (731) Market Street owner LLC versus the City and County of San Francisco, 50 Calap 5th, 937, a 2020 case. This is a Prop 13 reassessment case. We all know that if you transfer ownership of a piece of real estate, that you're subject to a Prop 13 readjustment for a change of ownership. There are, in some limited cases, real estate whose transfer does not trigger a Prop 13 reevaluation. This case involved a land lease in which you had a tenant who owned the building, and a landlord who owned the underlying fee. Turned out it was the same person, but held in separate entities. A lease was entered into for a 45-year term, 20-year term with 5 options to extend for the additional 5 years. For purposes of determining this analysis, the Revenue and Taxation Code allows you to add on option terms in determining what the overall term of the lease was. When a lease is 35 years old, or an existing lease has 35 years remaining, then a sale of the underlying property does not trigger a Prop 13 readjustment, because the beneficial owner is considered the tenant who owns the building, so that the underlying dirt can be sold separately and there is no increase. Court notes that when the building was sold several years before, there was a reassessment, as there should have been. So they said this would be a double dip, and certainly under the provisions of the Revenue and Taxation Code, it would not be appropriate to assert a adjustment because of the length of term of the lease, which effectively made the tenant the owner of the property for all practical purposes. City Mortgage versus Corto Madeira Homeowners Association. This is a federal case, 962 Fed 3rd 1103, 2020. This is a case decided under Nevada law, but it's instructive in terms of foreclosure procedures. In this case, the defendant Homeowners Association, by virtue of the CC&Rs, had a super priority lien for the homeowners assessments. There was a deed of trust on the property, originally it was originally Chase and got transferred to Bank of America. The Homeowners Association started to foreclose its assessment lien. And Bank of America said that they were an exception to the supermajority and that their foreclosure could not wipe out the interest of the bank. But just in case, the bank said, how much is the lien? What are you foreclosing on? And the response was that all of the requests involving the foreclosure were being handled by a website, and give your question to the website and you'll get an answer. Bank never did that. Homeowners Association proceeded and foreclosed. Bank of America sued for a wrongful foreclosure by saying, well, we inquired and we made a tender and we were never told the amount. And the court said, that's because you never went to the website to find out. It was not a wrongful foreclosure because you didn't do the necessary steps as a junior debtor. An interesting thing about the case is I used to do a lot of work for mortgage companies, making loans on condominiums and planned unit developments. And whenever they would make a loan, I would review the CC&Rs to be sure that there were the necessary provisions present to satisfy Fannie Mae and Freddie Mac. And one of the provisions was that there always was a provision in the CC&Rs providing that the assessment lien would not supplant a deed of trust on a loan that was recorded after the after the CC&Rs. So it's curious that that didn't exist in this case, because it was in every single CC&R that I reviewed, and I reviewed a couple thousand. Reader versus Specialized Loan Servicing LLC. This involved an alleged oral agreement to refinance or reamortize a home equity loan at maturity. In this case, the debtor got a home equity loan, a HELOC, and the loan officer with which he was dealing told him that when the line of credit becomes due, he can refinance it into a long-term loan. The HELOC came due. The borrower sought to refinance it into a long-term loan. Lender refused to do it. The property was foreclosed. There was a claim of wrongful foreclosure. The Court of Appeals based its decision on that eminent legal scholar, Samuel Goldwyn, who once said that a verbal agreement is not worth the paper that it's written on. And they said, here, this is a verbal agreement. It's barred by the statute of frauds. Besides which, the verbal agreement you described inadequately describes the terms of the loan, things like interest rate and things like that. So as such, it was unenforceable. During the savings and loan meltdown, this one was in the late 70s, I think. Lincoln Savings and Loan, for example, comes to mind. A lot of lenders went under and came into the jurisdiction and control of the federal government. And a lot of the borrowers said, well, I had this deal with the lender, I had that deal with the lender, and all of them got wiped out. And none of those verbal agreements were enforceable. The standard response of the government was, if you have a deal, show us the writing. If you don't have a writing, you don't have a deal. Which had a real impact on those debtors that were part of a daisy chain. That was a scheme in which when a bank foreclosed on a piece of property, they didn't want to have REO on the books. So they go to one of their customers and say, buy this property. And he says, well, the property isn't worth that much and I don't have the money. He says, that's all right. We'll give you a loan for 100% of the property. And we agree we'll never enforce that loan. And when the loan comes due, we'll simply have the property bought by another customer and so on. And so the ostensible value kept going up and up as it was being transferred. And after the savings and loan crash, the last person in line was saying, well, I was told expressly that I was never going to be held liable on this. And the Fed said, it's not in writing, write the check. Another case on foreclosure is Matheson versus SBS Trust Deed Network, 46 Calap 5th, 33, 2020 case. This was a case involving, in fact, actually last year, we had a case involving an antitrust action against a group of private bidders at foreclosure sales, which held that their agreement to divvy up which properties they bid on and so on was an antitrust violation. And the defense was that it was the only way they could compete against the foreclosing lender, because the lender knew everything about the property and they knew nothing. And the court said, no, it's a per se violation, therefore excuses won't help you. This is a case involving a bidder at a foreclosure sale who saw the property advertised, saw what the amount of the cure rate was on the deed of trust, concluded that there was a tremendous amount of equity in the property. And if the creditor was only going to bid in the amount of the debt, he'd overbid, and he made some significant money. So that's exactly what he did. Then he found out that the deed of trust was not the first deed of trust he thought it was, but a second deed of trust that sat behind a very large first, thereby disposing of all the equity he thought he was getting. Now, he had gotten his information from a website. He just merely relied on that. He attempted to stop payment on his cashier's check, which obviously didn't work, and sent a formal notice of rescission to the trustee and beneficiary, claiming he'd been defrauded. Well, he certainly wasn't defrauded by the trustee or the beneficiary. The trustee, despite the objections of the purchaser, recorded the deed, and the purchaser filed a claim for rescission, and the court held that a party's own error and reliance on information from a real estate website did not entitle them to rescission. Hardly a surprising result. It also highlights the danger that people bidding at these foreclosures take when they bid on a piece of property. They don't get a preliminary report. They really don't have any idea what the priority of the loan is, and obviously have no opportunity to inspect the property, at least on the inside. So it's a dangerous game. But some people play it very well and do very well by it. And others, like Mr. Matson, bitten on the rear end. Next case, another foreclosure case, Perez versus Mortgage Electronic Registration System, MERS, 959 Fed 3rd, 334. This is a Ninth Circuit 2020 case. In this case, the property owner defaulted on the loan, received a notice of default. A foreclosure sale was scheduled, but never took place. So we still own the property. Several years later, the plaintiff filed a lawsuit to bar a foreclosure. Excuse me, I had to decline my opportunity to buy a timeshare. Argued that because of a lack of clarity as to whether the foreclosing lender had properly documented the transfer of ownership, which is a standard even over versus New Century Mortgage argument, that he wanted a declaratory relief action declaring that the transferee did not have the right to foreclose. And the Ninth Circuit held that under Evanover versus New Century Mortgage, although the case held that borrowers have standing to challenge assignments that they allege were void, the holding was expressly limited to post-foreclosure actions for wrongful foreclosure, not to preemptive actions. You have to wait till you lose the property before you challenge the right of the creditor to foreclose. Now, last year, we discussed a case called Black Sky Capital versus Cobb. 7 Cal 5th 156, 2019 case. And this was a fairly important case in the area of secure transactions. In this case, the same lender held a first and a second on a piece of property. The first and second were entered into over a year apart. The creditor foreclosed on the first, and then proceeded to go after the debtor under the second as a sold-out junior. And cases up to that point had said in those circumstances, you can't rig the system in order to set it up to artificially create a unsecured debt. But in this case, they held that because the loans were given at separate times and there was adequate reason for the separate loan, that the lender could foreclose on the first and still proceed as a sold-out junior. This raises a whole series of questions about the effect of this case. It's not a blanket get out of jail free card for the creditor. And because the determination of whether or not they can proceed as a sold-out junior turns on facts, the question is, what advice do we as attorneys give to our clients who are lenders? Or the alternative, what advice do we give to our clients who are borrowers? The first advice you give to a lender client is don't make two loans at the same time without substantial and well-established business reasons. There must be a good faith justification for doing two loans. Otherwise, make it a single loan. When making a second loan in the period close to the original loan, like for example, within the same calendar year, better option is to completely refinance the property rather than making an ostensible separate loan secured by a second trust deed. If the borrower insists on a second loan, make it well documented. And if there are good business reasons why a separate loan must be made, for example, to accommodate the secondary market or something, those business reasons should be carefully documented. And if there are legitimate business reasons unrelated to maximizing the deficiency recovery, those too should be documented. Now, what are we talking about gaming the system? And why is this discussion necessary? One example of gaming the system is that the lender acquires the property by foreclosing under the first deed of trust, making its credit bid of the amount of the first deed of trust, which is below fair market value of the property. And there's no overbidder. The lender then sells the property for more than was owed on both loans, then turns around and sues for a deficiency judgment on the second note as a sold-out junior. So it's that kind of trick the courts are a little upset about. So what do you advise borrowers? Well, the first advice to borrowers is that because this is a legally esoteric area, pretty clear that unless your borrower client teaches a class on secure transactions in California, it's unlikely they're going to understand the nuances of non-judicial foreclosures and sold out juniors and what the risk in having a first and a second with the same lender. So clearly you should make sure that your borrower client is aware of the risk and why the borrower will be well served to avoid it. Borrowers who do not want a two-tiered loan, first and second, they want a refinance of the whole thing. If the lender refuses, once again, document the fact that they wanted a single loan. That will help in the analysis of facts as to whether or not the lender will be able to treat the second as a sold-out junior. If your borrower ends up with the first and second from the same lender and is getting into financial trouble, they can put pressure on the lender to foreclose on the first rather than the second by the simple expedient of not, excuse me, they can force the lender to foreclose on the second, not the first, by the simple expedient of keeping the second current. Oh, excuse me, of keeping the first current. So there's no ability to foreclose the first and stop paying on the second. So the only loan that the lender can foreclose on, the only loan in default is the second. So that's a possibility. The final possibility is a bankruptcy filing, possibly restructure under Chapter 11 or a 7 to get out from under of the sold out junior. So anytime you're dealing with a situation with the first and the second, which kind of comes up frequently because of HELOCs and similar things, but anytime you're in a situation where you have the same lender holding the first and the second, there are these problems to deal with, and these are ones that your client should be made well aware of. Back to this year's cases. C.W. Johnson and Sons versus Carpenter, 53 Calap 5th, 165, a 2020 case. This involves a contractor who's under contract to do a job. His license expired, so there was a period of time he did work on the job when he wasn't licensed. And as I'm sure we all know, one of the necessary requirements for a lawsuit to collect on your charges for contracting work when you don't have a license, you have to allege that you have a valid license. If you don't have a valid license, then you're not allowed to recover for that. The question is, does that invalidate the whole contract or not? Or part of the contract? And to what extent does the contractor have a defense? As to the first question, it's well-established law that someone who does work for which a license is required that doesn't have a license, but does work that requires a license and also does other work which does not require a license, is allowed to collect that portion of the work that doesn't require a license, but is barred from collecting that work that does. In this circumstance, where it was a not significant error on the part of the contractor, it just slipped between the cracks, the court said, was this guy licensed as a contractor before the contract? He was. Did he act reasonably and in good faith to maintain the license? Yes. Did he act promptly and in good faith to remedy the failure to comply with the license requirements? And the court said, yes, he did all that. And in those situations, it was not a serious enough violation to bar his recovery for even the work that required the license. Moore versus Teague, 48 Calap 5th, 280, 2020 case. This involves the measure of damages when a real estate agent defrauds his client. This was a case in which the agent convinced his client to buy a piece of property and do extensive remodeling, which the agent would do because he was a licensed contractor, which he wasn't, had significant experience in historic renovations, which he didn't. And then told the buyer that he didn't need a written contract. It wasn't needed because the agent had a favorable reputation in the renovation and construction industry, all of which were, of course, not true. Committed fraud. And the question was, what are the measure of damages? And the court noted that based on the tort claims, the fraud, the buyer was entitled to get benefit of bargain damages. He's not limited to the breach of contract measure of damages. The court said that the benefit of the bargain damages are recoverable when a fiduciary induces an individual to purchase, sell, or exchange real property to their detriment. And a real estate agent is a fiduciary when he represents the party in question. And our last case is a criminal action involving when the recording of a deed is fraudulent or not. In this case, it involved a criminal action against a foreclosure consultant who violated the statutory requirements applicable to a foreclosure consultant. The foreclosure consultant advised the homeowner to deed over their property by a quitclaim deed to a trust controlled by the defendant, told them to stop their mortgage payment and instead begin making monthly lease payments to the defendant. And then they'd have a right to reacquire the property by doing a balloon payment at the end, which of course never happened. There was a criminal lawsuit filed with several causes of action, one of which was Penal Code Section 115. Section 115 prohibits recording false or forged documents. The Court of Appeals held that there was no violation of 115 because the deed was signed by the person who owned the property and was voluntarily recorded by the person who owned the property. Therefore, 115 didn't provide because it was neither a false or forged document. For anyone listening to this who gets upset that this guy got off, the other counts were sufficient to sentence him to 28 years. And that's the last of the cases.
Larry, thank you very, very much for bringing us up to date on the 2020 cases. I want to invite everybody to look for our upcoming programs on foreign investors in domestic real estate, financing, and what's happened during the COVID-19 period. We're looking also to do programs regarding ADUs, which we're all seeing more and more of, and possibly short-term rentals. July, we will reprise a program with the speaker from the California Association of Realtors talking about their forms and any form updates and potentially their commercial forms. We may also revisit a lecture or a seminar we've done every 2 years, but it's been about 2.5 years on neighbor disputes that I helped put on. And we're also looking to do a program on construction litigation in the fall. Thank you to everyone for attending, and thank you again to Larry.
Welcome.